you should not anticipate that your adversary is going to have the same level of knowledge, experience, or paying attention to this than you do. They don't have the time or they don't have the motivation to do these things. And you can give yourself tremendous tactical advantages, for want of a better term, by being familiar with all these core foundational documents and taking a deep dive on them. Joe, do you have any final words for advice on anybody in terms of the importance of these things and putting them all together before trial so you're ready to roll?
Yeah, what I would suggest to you is prepare a form where, with respect to every one of the documents that are required to be placed into evidence by the prosecutor, all of the things that you need to check on each of those, whether it's the calibration, whether it's the solution change, whether it's the propriety of the solution itself, when did it expire? You want to put, what's the expiration date? Does this one coordinate with the alcohol influence report? Is it the same lab? Make a list so that you don't have to think about this. You go down the list, and so long as you can check off each one, you'll never have to worry like, geez, did I already do this? Let me go back to that other document. Prepare this list. It'll take you time, but it won't take you forever. It'll take an hour. And then from there on, you've got a list of what you can do. And as you get your discovery in, check off all of the dots, and if all of the items that you believe are required for the state to have done or proven or given to you have been checked off, well, then you know that this is admissible, so long as the prosecutor puts in all of the correct documents and doesn't forget one.
Let me give everybody one other thing that'll come up. It's not uncommon. You'll have one officer who did the arrest and a different officer who did who administered the test. Okay, it happens all the time. It may be that the officer who did the arrest is not authorized or trained in running the Alcotest. That's okay. It happens all the time. So the prosecutor calls the arresting officer in and he establishes what he saw and the tests he performed to get probable cause to arrest him. There may be some body camera footage that goes in, et cetera, et cetera. And now they want to put in the alcohol influence report and the related documents, except the trooper's not working today, so or the officer's not working. So, Judge, can we adjourn today and we'll come back, another time when the officer's on duty? And my answer to that is, I object. We're in the middle of a trial now, and there's a case on this, State versus O'Keefe. This is an old law division case, but it says, look, you're in a trial, and if the state doesn't have a witness, that's too bad. Okay, you do what you can, but it's unfair to the defendant to allow the state to adjourn a case because they're missing a piece of evidence and come back and, as they say in the case, sally forth on another day when they're better prepared. It provides an unfair advantage to the defendant. So if the state's not ready to go with everything at that point, you should be objecting and citing this law division case, State versus O'Keefe. Okay. Have you had that happen to you, Joe?
Oh, I have. I've used, it doesn't happen all that often, but I'll bet you I've had half a dozen cases, at least the DWI aspects of them. They could also be charged with reckless driving and failure to stay right and all of that. And that's because, what's missing is the Alcotest officer, not the officer who did the arrest. But I probably had half a dozen DWIs thrown out for that reason, where it was getting, the judge wanted to finish up the case that day. You don't have the witness there. That's great. But the arresting cop who followed your client, well, you can get him for going over the center line, driving recklessly, all of that. But you may not be able to prove the DWI.
Right. So remember State versus O'Keefe. Even though it's a law division case, it's still good law and very persuasive argument you can make to the judge, and certainly something you're going to want to preserve in the event that the judge gives the state an adjournment. Again, you have a continuing objection, and I think that'll have legs when you get to the law division in the event you have to appeal that. I would think it would have legs. Don't you think so, Joe?
Yeah, even a law division case gets its imprimatur from the state deciding this is worthy of publication. That tells you that they believe this is a solid decision based on solid law. And even though it's not in the active or Supreme Court, this is something that everyone should be following.